Welcome back to Face to Face. I'm John Ralston. The state is going to have to change the way that juveniles are certified. At least that's what the state Supreme Court says, throwing out a seminal part of Nevada law thanks to a motion filed by Kristina Wildeveld representing a couple of juvenile clients. We have the deputy DA who argued against what the Supreme Court did. Let me show you, Ms. Wildeveld, what you wrote in your motion to the Supreme Court about one of your clients who was 17 at the time he was charged. If he had 3 wishes, he would wish to 1, change his life around, 2, to do better things, and 3, for his mother to be, quote, okay because of her cancer. The competency report stated that Marcus was unable to state the specific charges, but that he knew they were serious. His understanding of pleading guilty and pleading not guilty meant that either you did it or you didn't do it, but he was only able to appreciate some of the consequences for pleading guilty or not, and that the court would tell me what they are going to do with me. Did you have no success in explaining to him what this all meant?
Marquise is a wonderful kid, but it's very difficult to communicate with him. Even to call him and let him know about the Supreme Court decision was extremely difficult.
To explain why to people so they really understand.
Well, he has a mental capacity. He has an IQ of 74. He's slow. He's a very nice kid, but he's slow, so it's difficult to communicate with him.
So it's difficult to get him to understand. But doesn't that fit into the extenuating circumstances then that she was talking about before? And so why would that be an issue then? Explain that.
Well, this is the extenuating circumstances that we're talking about. He has a very low functioning IQ. And that's a reason to keep him in juvenile court.
Why is that not a compelling argument? It seems to me, someone with a 74 IQ, why would that person who's underage, why would that person ever be certified as an adult? Explain that.
Well, I mean, in this case, you have to look at the facts of the case as well, because part of this is the type of crime that we're looking at. And in this particular case, it was an armed robbery of 2 people in the park where shots were actually fired. One fired in the ground, and then as the victims were running away, more shots were fired. One of the individuals had a gun put to his head. These are very serious, violent offenses, which is what the legislature was looking at. And this juvenile was 17 years old. He's at the top range, and we're looking at very offensive, violent acts. And there has to be accountability, and that's what the legislature was looking for. So we have to balance the two. And in this particular case, the judge had found that he should be certified. And I believe that you have to look at the violent nature of the crime. This is exact crime that the legislature was looking at.
No evidence has been heard yet. Nothing has been heard in 2 years. He denies that he was even there. And if he was there, he's not the person alleged to have had a gun. That's my point. So take the person who had a gun, put them up to adult court. Take the person who shot and endangered people up to adult court. But the kid who may have been there, may or not have been there, with a low functioning IQ, who doesn't even know probably what he's doing in the first place, don't take him and certify him up. Get him some help in juvenile court so he doesn't reoffend.
Well,
so he learns right from
you're
wrong.
basing what you're saying on a lot of assumptions too, that he didn't know what he was doing, that he didn't know that there was going to be violent acts committed. Are you sure of that?
No, but I know that it's very difficult to communicate with him. I know that he functions at a very low IQ. So if he was there, did he go along willingly and do something with these other boys who have juvenile history?
But there were victims to this crime that identified this subject minor, which is what we call him in juvenile court, this juvenile offender, as one of the individuals with a gun. He was identified as in a photo lineup as part of the report.
Are you sure you have your facts right on that? Or was it the cell phone that he ended up in his possession?
No, I actually checked the facts this morning before I came here, and he was identified as one of the people with a gun. So we have an individual with a gun. Whether he was one of the ones that fired, I'm not sure, because he was running.
He had a weapon. He could have committed a violent act. I mean, she's making...
Was the gun loaded? Was it a pellet gun? Was it a water gun? Do we know any of that things?
Yes, the crime scene recovered 3 shell casings from the park. So we know it was actual guns that were used. One was fired in the ground. Other shots were fired.
Okay, hang before you jump. Hang on. I don't want to start talking about the jargon again. What does your office do? I mean, she's making all these hypotheticals with a water gun. Was the gun loaded? How much investigation do you do before you go in and say this person should be certified? Just because the kid had a gun, is that enough for you? You know, then we got to go for certification? Or is more done to find out, was it a gun? Was it a real gun? What kind of priors does this person have? What are the factors that you're using here?
Yeah, we do look. When we file for, we only have a certain amount of time to file a a petition. We then make a decision on whether to file a motion for certification. Once that happens, then there is an investigation into their background, their prior record. We look at what the police submit to us, but we have to remember the procedural aspect where we're at in this point. This is not a guilt or innocence phase. It is only, is it going to be tried in juvenile court or is it going to be tried in adult court?
Hang on just a second. Did you know he was mentally challenged when he asked for certification?
I was not the deputy that did the certification.
Do you know the answer to that question?
They would have known during the process once there was a psychological evaluation done and once there was a certification report done.
I know you want to jump in. I know you want to jump in, but we have to take a break. We're going to come back and resolve all this and find out if the state's made a decision on whether to go forward to the state Supreme Court again or maybe all the way to the U.S. Supreme Court. We'll ask. We may not get an answer, but we're going to ask. Back in a moment.